Okay, thank you. Let's come back together. We are ready for our next panel, which is the state legislative update. And Jana Turvey is the moderator for this panel, and she will introduce the two panelists. So, Jana, thank you.
Thank you. Can you hear me? Am I live? All right. I'll just trust that you all can hear me. If not, you can start waving or yelling or doing whatever. I am Jana Turvey. I'm one of the co-chairs of the Alaska Native Law section of the Alaska Bar, and I want to thank you all for being here today. I was given the appointment of bringing together the state legislative panel for this afternoon. Full disclosure, we have state legislative, regulatory, and case law update for the next 40 or 45 minutes or so. I have two wonderful folks here with me today. We're going to introduce them separately so they can go through their respective presentations. Similar to the federal legislative update you just heard, they are on complete opposite sides of the spectrum, so they'll keep your attention. It'll be great. So first today, we're going to talk about the new proxy solicitation regulations that were recently released. And with us today is Kevin Anselm. She is the director of the Alaska Department of Commerce, Community and Economic Development, Division of Banking and Securities. And she was appointed to this position in 2013. She joined DBS in May of 2011 as the Enforcement and Securities Chief after serving in a similar capacity for the Oregon Division of Finance and Corporate Securities, otherwise known as DFCS. Ms. Anselm previously worked as a securities examiner at DFCS from 1989 to 1994, returning to that agency in 2006. In the interim, she served in various state positions, including as an administrative law judge and deputy chief administrative law judge at the Oregon Office of Administrative Hearings. She holds a Bachelor of Business Administration and Management and a BA in Political Science from the University of Portland, and got her Juris Doctorate and Certificate in Dispute Resolution from Willamette University College of Law. She is currently a member of the Alaska and Oregon bars. And I would like to thank you for joining us today, and we really look forward to hearing this wonderful information.
Thanks. Well, we'll see how I do with technology. It's not my strong suit, as my staff will tell you. So, good afternoon. This has been a great conference. It's been very interesting to hear the various perspectives, and I'm really pleased to be here. Before I talk about regulations, though, I want to give you a little bit of background about what our office does. The Division of Banking and Securities responsibilities include protecting consumers of financial services and promoting safe and sound financial systems. And that supports the department's mission, which is to promote a healthy economy, strong communities, and protect consumers in Alaska. We have a number of programs that we're responsible for in the Division of Banking and Securities. Of course, we work with the Alaska Native Claims Settlement Act corporations and the shareholder proxy filings, and that'll be more of what I talk about in a few minutes. We also regulate securities broker-dealers and investment advisors, sales agents, securities filings, and these are filings from issuers and agents, mortgage lenders and loan originators, money service businesses, payday lenders, small loan companies, premium finance companies, chartered financial institutions, so our state banks, state credit union, banks, trusts. We work with the BIDCO, the Business Industrial Development Companies, and CFAB, the Commercial Fishing and Agricultural Bank. So as you can see, we have a few things going on. So I wanted you to see what that looks like. The division, and this is one of our charts that shows what we've been doing both historically and currently, starts in fiscal year 2007. On the right side of that graph are the number of positions we have in the division. Right now, that black line there shows that we have 23 positions. At the top, or on the left side of the graph, indicates how many applications, registrations, filings, licenses, and agents we have in the securities area. That is 105,000. It's a lot of entities to deal with on an annual and ongoing basis. So you'll see that the ANCSA information is not on this chart. Whoops, wrong way. See, it's the technology thing. Here's the other part of what we do, and it does include the ANCSA filings that we receive, and they're near the bottom there, the darker red. This includes what's not included here are the investigations and enforcement actions that we take. Those are somewhat variable every year, but I'll mention some of those as we go through the rest of the presentation. There are also some materials in your packet that I'll be referring to later in the presentation that covers three things. Those three things are the ANCSA regulation changes from 2011 to the present, some current regulations, or actually the current regulations after the March 2016 amendments, and then finally, we included a copy of the information that we have on our website and available in pamphlet form for ANCSA shareholders and for ANCSA corporations. So those are the documents that you'll find in your materials. So let's walk through a brief history of what has happened in ANCSA so far that our division works with or is affected by. In 1971, ANCSA was passed by Congress. In 1972, the first Alaska state statute was passed to indicate that initial ANCSA stock issuance is not the sale of a security, so that it exempted the ANCSA corporations from having to comply with the registration provisions of the Alaska Securities Act. In 1977, there was an additional statute which required filing of various documents, information with the division. That was basically anything that was distributed by anyone to more than 30 or more resident shareholders if they were also part of the ANCSA corporation that was worth more than, or had over $1 million in assets with 500 or more shareholders. That number has grown over the years, by the way. There's more to the history. In 1981, the division promulgated the initial regulations, amended those in 1988. In 1999, there was a legislative audit report. And for those of you who have not seen that, that is public information and can be provided. The Legislative Audit Group basically came in because there were some complaints about how ANCSA matters were being handled, and so they looked at 3 years of information. They came out with some regulations, and the division responded to those recommendations. There was there were not very many regulatory actions taken between 1999 and 2011. In 2011, and you'll see the three most recent regulation packages highlighted in blue. There was a reg package in 2011. Right after that, in fact, during 2011, the Government Accountability Office came into Alaska to review the ANCSA program. That's a federal agency. They reviewed the program by meeting with the corporation representatives, State of Alaska representatives, and others, and then issued their report in December of 2012. They had some recommendations as well, and in fact, that report, and I included the number on here, 13-21. If you look it up, you can see it on the internet. There was a statutory change right after that based on, it was basically triggered by the GAO comments that clarified that qualified after issued stock is exempt from registration. We talked a little bit about after issued stock this morning. And so you'll see that that was quite important to do, so that there was no requirement to meet State of Alaska securities registration requirements. And then most recently, there was a set of 2016 regulations, which I believe is still under a bit of discussion. We know that there are still some concerns and frustrations with the Alaska law and the regulations, and it's understandable. Unfortunately, ANCSA statutes were shoehorned into the Alaska Securities Act long ago. And frankly, that limits options about what can be put in the Securities Act relating to the ANCSA corporations because they simply don't fit. So what do we do about that? Well, there is a proposal to lift the securities-related provisions out of the Alaska statute. That's AS 4555. And that would be called the Alaska Securities Act. Let me tell you what would happen there. If we separate the securities statutes from the ANCSA-related statutes, it would reduce some confusion and improve the understanding of both acts. It would recognize the substantial differences between the ANCSA provisions and the securities industry issues and concerns, and those are marked. ANCSA provisions really deal with closely held, non-registered, inalienable stock. The Securities Act deals with all of the other kinds of stock that is traded on exchanges, stock that is purchased through limited offerings. It deals with mutual funds and unit investment trusts and real estate investment trusts and things that really don't look like ANCSA shares. Splitting the two statutes would ease the difficulties and conflicts in changing statutory provisions in each statute, which means that can support changes in the in regulations that many of the ANCSA corporations and frankly others that deal with ANCSA issues, as well as I will tell you it would be easier on the state side for us to meet some of the concerns that both the corporations and shareholders have. And we would certainly have an opportunity to have a broader discussion about what we're able to do in either regulation or statute. The result would be ANCSA-related provisions would remain in AS 4555, and the statute change would lift all of the other securities regulations, the securities statutes and regulations out of that statute and put it in a new statute, 4556. This isn't a new idea. This was actually proposed last year and was in the process of going through the legislature and had a lot of support. Unfortunately, we ran into, I guess I'll call it a bit of a gridlock that had nothing to do with either ANCSA or the securities statutes when there was, I guess there was a disagreement on money. And so the bill that was there were actually two bills. One was going through on the House side, one was going through on the Senate side. It was House Bill 194, Senate Bill 108. Those basically died in the Rules Committee without being able to get to both floors. So I have permission to tell you that this is coming back, and we're hoping that the Native corporations as well as shareholders will be willing to support this action. Now, the new act, well, actually, the old act would be renamed. 4555 would be renamed, and this is according to the reviser's instruction that is currently in 194 and 108. Alaska Native Claims Settlement Act Corporations, Proxy Solicitations, and Initial Issuance of Stock, so that there is no confusion about whether any of the other Securities Act requirements would apply. So, as I mentioned, we expect that this bill will likely be introduced at the first part of the next legislative session. Our office is pleased to answer any questions that might come up in the meantime, and I know that we'll be working with the ANCSA corporations to see if there are any questions, concerns, and other issues that are raised or could be raised during the course of this legislative session. So if you, like I said, if you have questions, you can call our office, and I'm going to have a couple of people stand up so that you know that I'm not the only one that you can talk to. Christy Naylor, who is our Chief of Securities and Enforcement, and Renee Wardlaw, who is an Assistant Attorney General and helps us with all ANCSA issues. So I'll close there, and then if there are questions, I'm happy to answer them now or later.
Any questions? Well, I have one.
Yes.
You mentioned that you would be seeking Alaska Native Corporation and hopefully shareholder support when HB 194, SB 108 is reintroduced. How
Yes.
would you like? How will you be soliciting that endorsement, I suppose?
Typically, we start working with the Alaska Regional Corporations group, and then also reach out to the villages group. And if there are some other areas that if we should be talking with others, I would be pleased to have that information.
Okay. Great. Well, thank you.
So did you have a question?
I did.
Oh,
go ahead.
It's actually, no. It's actually perhaps more of a general question based on, going off your presentation, which is that given the effort here to recognize that the corporations are different, would this apply to other issues facing the corporations, which don't deal so much with the stock, but deal with registration issues that are dealt with by corporations, as opposed to the stock issuance? So basically, biannual registration and agent addresses and things like that. Is that also something that would be separated out, or are we just looking at stock issues right now?
This statute deals only with the stock issues, the shareholder issues, but not the actual corporate registration, and that's through the corporations and professional licensing area, and that's also a different statute.
Right, so what I'm saying is could this effort be seen as a precursor in some ways for the other, given the unique issues that corporations face with some of those? And I know it's not really a question for you, it's more of a general question or a general thought.
And I don't know, I can't really respond to that since that's not an area that our division actually deals with, but I think it's certainly worthy of discussion, and I can certainly put you in contact with the people who would be the ones that would likely
Just
want to discuss
curiosity.
that.
I actually don't do corporate work, so yeah.
Thanks.
I have less of a question and more of a comment. I wanted to really express some appreciation to the division for working with us on this. There are some of us that have been working on changes to the proxy regulations since sometime before the invention of time. I know there are a few of us that have been looking at it since that legislative act report came out in '99, and then I think we seriously got down to drafting revised regulations, including some people that are no longer with us. I know Keith Sanders was a big effort on, put in quite a lot of effort on that process. Keith's since gone on. But there are some of us that have been doing this for about 10 years, and we really appreciate the effort that the division put into it and their cooperation and working with us and listening to what we had to say. I know we didn't always agree on everything. That was perfectly fine. We really appreciated the back and forth on it, though. Thank you.
Thanks. Do you see a benefit in having the regulations governed by a statute that is outside of the Securities Act? Sorry,
In respect for the mic, I'll wait. I think so. I think in general the concept is good. I think there will be some questions about exactly how things get parsed, but certainly in general I think that's a sound idea.
Thanks. We'll be interested in more comments.
We'll have a lot.
I'm glad. I'm glad. We count on that. Thanks.
Thank you. So moving on to our next presenter, as I promised, we'll go to the complete opposite end of the spectrum. With us this afternoon, we have Matt Singer. Matt is a trial lawyer with Holland and Knight. He represents a number of Alaska Native corporations on access and right-of-way disputes, including land and natural resource matters. He's co-counsel with Howard Trickey, excuse me, with an OTNA issue that I was actually involved in as well when I was at that regional corporation. This case has been ongoing now for 8 years, Matt? Something like it's been a long time, and it continues to go on. And we've had a number of different CLEs on this particular topic, but things have developed in the course of the last year or so, and so we thought it'd be great to have Matt come back and give us an RS-2477 primer and case law update. So welcome, Matt.
Thank you. Yeah, I appreciate the opportunity to be here today. So what I hope to do is spend 5 or 10 minutes to tell you what RS-2477 is and explain how it works, and then to tell you about 2 recent trial court decisions here in Alaska that are significant and may, if they're affirmed on appeal, could represent some change or evolution in the law. And RS-2477 is a 150-year-old statute. It's 21 words long. Here in white, this is the statute. It provides that a right-of-way for the construction of highways over public lands not reserved for public uses is hereby granted. 21 words that have caused lots of litigation and lots of consternation for property owners, and particularly for Alaska Native regional corporations and village corporations, because those entities are some of the largest private landowners in the state. Unlike other sorts of property interests, RS-2477 is it's a highway easement it's called a self-executing grant. It comes into existence as a result of historical fact, as a result of how people use the land historically, and there are no formalities required. And that's really different than other kinds of property interests. If the utility company has an easement across your backyard, that's recorded when you buy your property and do a title search. You see that there's an easement across your property. RS-2477s have not traditionally been recorded, so they're a highway easement that might run across private property, but there be no formal government record of them. And they, as I said, they exist or they don't exist as a result of historical fact. And I'll explain why that creates all kinds of headaches for lawyers. The RS-2477 was repealed in 1972. And so from 1866 until 1972, the way it works is if there was public land, that is land that hadn't been set aside as a national park or hadn't been set aside for a specific purpose, general public land, BLM land, or other public federally owned land, if there was public use of that land in a manner that established that the public intended to create a highway, and a highway is a very liberally defined term, then the law has developed that a right-of-way exists in that place. So a highway is considered to be essentially a trail that goes from one place to another, and the court evaluates the extent and frequency with which the public use the place, the duration of the use, the nature of the use, and if there's a definite character of the route. So here in Anchorage, DeBar Road, for example, is an RS-2477, and that's because while it was still public land, there was an established route from one place to another sufficient to create a right-of-way there. The interplay with ANCSA that's interesting is when the Native corporations were given the right to select land for conveyance, it was subject to valid existing rights. And that's so even if those rights weren't recorded or otherwise identified. And so land selections were done by village corporations and by regional corporations, mostly without any knowledge that the state may, at the time or sometime in the future, claim that the state owns a highway easement across the property. After ANCSA and after many of the land selections were completed, the state initiated its RS 2477 projects. So the Department of Natural Resources, beginning in the 80s and 90s, started researching and identifying historic trails all around the state, and identified over 650 trails, and then had the legislature enact a statute to codify the existence of the state's claim to these trails, so that the statute doesn't actually make these trails, doesn't assure the state that these are highways, but it establishes that the state claims that there's a highway in these places. And then the legislature funded a position at the Department of Law to litigate and prosecute highway right-of-way claims on behalf of the state. And so the department has a lawyer who, for many years, his only role has been to identify right-of-way disputes and prosecute them on behalf of the state. So the Department of Law and Department of Natural Resources and the Department of Transportation have looked for test cases to try to push the law and assert the state's rights to access along these historic trails. And Department of Natural Resources has a unit called the Public Access Assertion and Defense Unit, and this is a key part of their role. As an example of how many of these highway trail easements may exist in Alaska, here's a picture of our road system, our existing, the Glen Highway and the Parks Highway, and there's one road coming into town and one road going out of town here in Anchorage. Here's a slide that shows ANCSA lands in Alaska. These are lands that were selected under ANCSA by regional or village corporations. And then here's if you could see this, and I think these are in the materials that were distributed as well, but here's all of the state's claimed right-of-ways, highway right-of-ways. And there really isn't any significant ANCSA holding that doesn't have a state claim of a highway over it. This is an example here in our region, the Siri, Chugach, and Otna regions, and there's a web of trails that the state claims are historic highways. I included slides for each of the regions. I won't go through all of those here, but the point is that this is sort of a sleeping dispute for private landowners in Alaska, and especially for Alaska Native interests. Let me turn now, because I don't have a lot of time, let me turn to the two cases that I wanted to give you an update about. One is the case that we've been involved with for Otna now since 2008. Actually, the case started in-house at Otna, and then at some point my partner Howard Trickey became involved in it, and we've lived with the case now for several years. It's scheduled to go to trial in April of 2017. It'll be 9 years after the case was filed. The dispute involves the Brennick Craig Road, or the Clutina River or Clutina Lake Road. This is a trail that goes from the Copper River, essentially from the Copper Lodge, Princess Lodge in Copper River, up the Clutina River to Clutina Lake, to the mouth of Clutina Lake. And there's an established easement under ANCSA 17B. There's a public easement that already exists on this road. It's a 60-foot wide easement. The road's actually not much wider. It's really a trail, not much wider than one of the desks that you're sitting at. It's an rough ATV trail. I've seen a couple of pickup trucks up at the lake, so there's a few hardy souls that have driven it in a passenger vehicle, but it's really a rough road. And there's a 1-acre BLM recreation site by the lake, and it's a beautiful setting. And this dispute arose originally because Otna put up a fee station and a permit station, and the state went and ripped it out and said, "You're trespassing on our historic trail. You can't require people to have camping permits." And Otna sued for trespass. The state filed a counterclaim and said that they wanted quiet title and establish that there's a historic trail here, and so the state has a 100-foot highway easement over the trail. And the state's main theory is that the trail was established over 100 years ago during the Klondike Gold Rush, and there was, for a very short period of time, there were some hucksters on the dock in Seattle who sold tickets to the all-American route to the Klondike gold fields. And what they told people is you can stay in the United States and it's a shortcut. And people bought tickets on steamships and were dropped off in Valdez and pointed over the glacier. And it's that away. And lots of people bought these tickets and headed over the glacier and down to Clutina Lake. Somebody built a schooner on Clutina Lake and would sail gold miners across the lake to the mouth, where they would build riverboats and try to run down the rapids down to Copper Center. Lots of people met their demise on the river. It was a very challenging, there's some big rapids. And a couple tent camps were established along the way. And there's some people went up and down on the, we think for the most part people traveled by water, but there was certainly some movement on ground as well. And it was from 1898 to 1899. It didn't take long before word got out that this was a terrible way to get, and that you ended up in Copper Center, not the Klondike. So it was but the state says that activity was sufficient to establish that the public intended there to be a highway in this place. And then they also rely on some modern construction, and this is in the 1960s, a fellow named Mr. Brennick and a fellow named Mr. Craig had a bulldozer. They got a little bit of, I think, $6,000 or $8,000 in diesel money from the state, and they started bulldozing what is today the Clutina River Road. And the state says, we funded road construction, and we did it while this land was still public land, so therefore it's a 100-foot, today it's a 100-foot public highway, or it should be. When at some point in the litigation, the state filed a counterclaim this really derailed early resolution of the case when the state made an assertion that in addition to a 100-foot wide easement from the Princess Lodge up to the lake, they also wanted easements to 41, they call them spurs and arterials. This is boat launches and campgrounds and day use areas. And the state said that these were part of the historic use of the area. And so they also, these amenities should also belong to the state of Alaska. And Audit saw this as a real assault on its private property rights. I mean, can you imagine if somebody said that in addition to a right to share a driveway with you, they could also set up and camp in your front yard, because that's how it was historically used. So we've had a significant disagreement with the state about whether a highway easement allows camping and picnicking and fishing and all of these amenities or not. And the state, we felt, took a very aggressive position, and our position was, if there is a historic trail here, it's for egress and ingress, not recreation. A highway easement is for getting from one place to another. It's not a site easement. It's not a fee simple interest in land. So we put this issue to Judge Guidi recently, and he entered a summary judgment order in favor of our client, in favor of Audit. He rejected the state's claim to campgrounds and day use sites and boat launches, and he said that the statute conveys a right to pass over land and nothing more. It does not grant easements for recreational uses unrelated to travel between two definite points. So this was a significant victory for Audit. It really solves one of the major problems with the case, because Audit selected this land for its subsistence value, and also because it may potentially have economic value to the degree that people want to go visit there and recreate. Audit should enjoy the benefit of that recreation. It's Audit's private land. The judge wrote that the statute did not and cannot now, 40 years after the statute's been repealed, cannot convey the right to develop the land for recreational and commercial purposes. So Judge Guidi issued a decision that's a very strong private property rights decision that's a positive for Alaska Native property owners. The state really didn't like that decision. It filed an immediate emergency motion for, it wanted an interlocutory appeal and told the Supreme Court that the sky was going to fall and this would affect management of every highway in the state. And the Supreme Court wasn't interested in hearing intermediate review and said, and rejected the state's appeal. And so we'll march on towards trial of the case. The other case, very recent case, is called Dixon versus State. And this was the plaintiffs own an old homestead out in the valley on 240 acres. And there were dog mushers were running across it. And they brought quiet title action to halt trespass on their property. The state entered the case and countersued and asserted that there were historic trails that were RS 2477 right-of-ways. And the court ultimately found that the historic Iditarod Trail partly crosses this property and that there is a RS 2477 highway on the property. One of the things that was interesting about the case is just the effort that was involved. And because these easements either exist or don't exist based on how people use the land 100 years ago or 70 years ago, they're very fact-intensive and expensive disputes. The Dixon versus State case was a 27-day bench trial that went over 3 months. So the judge would hear testimony for a couple of weeks, and then it was Judge Easter, she had other hearings, and then, so they'd find some more time, and they'd come back, and it just went on and on and on. And I was stopping in to see the trial, and it was, it seemed like they were always talking about the same thing. And it was a very thorough exploration of these issues. And the state had historians and photogrammetrists, land surveyors, GIS software experts, a LiDAR expert. LiDAR is a technology that can look through foliage at land underneath. And they had a LiDAR expert who said if you cut away the trees, you can see that there's a little trail underneath. And it's really an extraordinary effort. Neighbors, former owners, current owners, dog mushers, all of these people came and testified in this trial. The judge wrote I think it's a 55-page single-space decision. So I think what's significant about the case is a couple of things. One is just how fact-intensive this can be. And think about the burden for these property owners. These folks felt that their families had homesteaded and they owned these 240 acres and should be entitled to expel trespassers. And so they brought what they thought was a simple property quiet title action in court. And they ended up in a battle royale with the state of Alaska, and the state had limitless resources. And I don't know how these property owners stayed in the fight for as long as they did. And expert witnesses and the complexity and the cost. The state, after the state prevailed in the case, filed a motion for attorney's fees. And it was very unusual. They asked for 100% award of fees. And they said that there's a discovery device called a request for admission. So they had served the property owners with requests for admission. The property owners had disputed some of the facts. They disagreed with the state's view. And the state said that the judge should sanction the property owners for disagreeing with what the state ultimately proved at trial, and should award 100% of the fees. And they asked for $1 million. And the state had almost 5,000 hours of attorney time into the case, which, for me, that would be 2.5 years of a very busy litigation years would be to do that. It's really astonishing the resources that the state put into the case. The judge rejected the state's request for 100% fees, but she applied the standard Alaska Civil Rule 82 and awarded costs as well. And so the property owners owe the state of Alaska $225,000. and they now have a 100-foot wide highway easement across their homestead. So those property owners have appealed to the state Supreme Court and have raised a number of points on appeal. So that we'll see what happens with that case. So what I'll leave you with is that this is a sleeping issue for private property owners in rural Alaska, and particularly for Alaska Native regional corporations and village corporations. And it's an issue that will continue to evolve, and we're hopeful actually that the state's current budget crisis might cause some reevaluation of priorities. That could be good for our clients. If there's any questions, I'm happy to answer them. I appreciate the opportunity to speak to you today.
And just as a point of clarification, we were not able to print out the slides because they were in color and it was just not going to work. But they will be available on the website. The URL is up there. They'll be available next week. So I certainly encourage people to look at them. One of my colleagues has a RS-2477 all of Alaska map up in her office, and it is amazing the extent of the trails, and especially in rural areas, all these trails you wouldn't think were trails. And so this really is a big statewide issue, and I can certainly, it doesn't have a corresponding map of ANCSA lands, but I can certainly understand why there would be this this convergence of the two issues. But any questions from anyone in the audience before we take our break? Just a sec.
Great presentation, thank you. Do you know whether the AG position is still slotted and filled with existing economic constraints? And secondly, how would you expect, having been deep in this thing for so long, that these RS-2477s would crop up on a private landowner's parcel? Would it just be at the time of development when a permit is applied for, or is there somebody actively going out and trying to make all of those red lines turn into green?
So with regard to the budget question, I'm embarrassed to confess that I've been a very careful student of both the Department of Law and the DNR's budget over the last few years as I've been scratching my head about how to get this thing resolved. I've been every year, I talk to my friends and, is there going to be money this year for this public access defense unit? And so far, both the DNR unit and the Department of Law position have continued to be funded. And so the state has made this a priority. There are different views on this. So I, both personally and on behalf of my clients, I think, the basic bargain in ANCSA was that the corporations were receiving fee simple private property title to the lands that were conveyed. The other side of the coin, the state's perspective over the last decade or so, has been that it's important for development and for recreation to assure public access. And so entities like the Alaska Miners Association or outdoors groups like the Alaska Outdoor Council, they have been advocates of aggressive enforcement of RS-2477 rights. So there are strongly held divergent views on this issue, and the legislature has up and through this current year has seen it a sufficient priority to budget to continue these fights. That may change. My sense is this administration may have better or different priorities than prior administrations. And then the question was, how do these things come up? I've litigated several of these cases, and they come up in a variety of ways. So one of the cases I litigated was a dispute between private property owners out in Bristol Bay, two fishing lodges, and one fellow was on the lake, and he didn't have a good place to tie up his float plane, so he came around to my fellow's riverfront property to tie up his float plane, and then he drove his four-wheeler back and forth. My guy said, "Stop trespassing." We brought a trespass action. He sued and said, "No, there's a historic trail that happens to run from where I like to tie up my boat to my lodge on this isolated peninsula on Iliamna Lake. And we had a week-long trial, and we had an historian, and we had aerial photographs, and so there it came up and I think this comes up a lot. It comes up as it did in the Iditarod Trail. It comes up because one person or another either wants to prevent use or puts up no trespassing signs, or somebody else is trying to gain access to property. I think for an entity like CIRI or a native corporation, it could come up if there's a mineral development or oil and gas development, and the company's looking at how are we going to access this site. You might see it try to prosecute the existence of a historic trail. So you could be sued by the state, or you could have a private party asserting that a historic trail exists. It's a couple different ways it could come up. Good question.
You have a question over here?
Thanks so much. I was just wondering if you could comment on, I see a lot of overlap in what they're doing with the RS-2477 and the navigability determinations. I think it's a parallel sort of process of what they're doing and issuing permits to public or so-called navigable waters without any federal title to those waters, just under their own administrative determinations. So I just wondered if you had comments on that. And then sort of as for practice tips, I'm wondering, if you wanted, would you suggest adding like an animal behaviorist to your list? Because if it's a game trail and they're trying to use these radars to figure out that the soil has been packed down, well, yeah, I mean,
right.
There's geology in there too, all those different things. But if you have any, for private practitioners, we went to law school because we didn't want to deal with the facts. We didn't want to be historians, and just if you have any resources in terms of, without the state's resources in terms of doing all this research, if you have practice tips of where to look.
Well, I think in terms of practice tips, let me give you an example. In the dispute for Otno, we've worked with a linguist whose his career has been studying Otna place names, and those place names tell us something about historic use of the place. And so we're using his testimony to help tell the story about use of the place prior to the gold rush era. Working with a cultural anthropologist who's looked at the entire history, he's been out on site to help tell the story of human use. And we want to show the judge that people tend to use the most efficient route from one place to another, and here the most efficient route was, to the degree it made sense to be there in the first place, it was a water route. It wasn't a terrestrial route. And then we're working with an archaeologist who's done field studies on the site. So I think each case is different, but there's a lot of room for creativity. The state in the Dixon case, every historic map of the old Iditarod Trail showed the trail to the north of the plaintiff's property. There wasn't a single map that showed the trail on that property. And so the state argued, well, all the maps are wrong. And they were able to convince the judge that all the maps were wrong. So there's a lot of room for creativity. You're right, the state has taken a very similar approach in fact, we have another dispute for Otna that's hopefully close to resolution, but it's involved navigability. And in that case, there's as there are throughout Alaska, you have meandering rivers. So you might have a small braid of water and a huge gravel plain. The state takes the position that everything between the foliage on one side and foliage on the other side belongs to the state and is part of a navigable waterway, even if you might only have, a tiny dribble of water down the middle. So the state's been very aggressive about asserting navigability. If you can get a little rubber raft down the river, the state claims it's navigable and belongs to the public.
More questions? I think maybe unless Jana had anything else, we'll take a break.
Sorry, quick question. Can you speculate to the motivation of the state asking for attorney's fees in that Iditarod Trail? Were they sending a message?
Well, I think so. I think so. I think they were sending a message. I think I suspect that there were people within the state government that were questioning the investment in that case, and so recovering 100% of fees would solve that issue. I mean, it's also just a, if you put on your Department of Law hat, they're looking out for the taxpayers or the, you know, the public, and to the degree that the state has a right to collect fees, that would go into the general fund and offset the cost of the case. But it's very aggressive. I've been practicing law in Alaska since 1999, and about 90% of what I do is represent plaintiffs and defendants in lawsuits. I've never seen a claim for 100% attorney's fees under the discovery rules. It really wasn't a well-supported claim, and the judge didn't grant it, but it was it's very aggressive.
Jana, do you have anything more?
I don't have anything more other than to say thank you to my two panelists. I think based on the questions that you both received after your respective presentations, the audience was engaged. You gave great information. I want to thank you very much for being here today, and I think we give them a round of applause.